Last class we have discussed Unit 1 and 2. Today we are going to discuss Unit 3 and 4. So Unit 3, as you can see the contents, Unit 3 is Memorandum of Association. A Memorandum of Association or MOA is often regarded as the charter document of a company. It forms the basis of the company's existence and defines its relationship with the outside world. The MOA sets the boundaries within which a company can operate and is a public document accessible to all stakeholders. Detailed contents of the MOA. First one is name clause. This clause specifies the legal name of the company. For example, a private limited company must end with private limited, while a public company uses limited. Restrictions are the name should not be identical to an existing company's name and should not include prohibited words like government or national unless special permission is obtained. Second is registered office clause. This clause mentions the state or jurisdiction where the company's registered office is located. The address is critical for legal correspondence and determines the legal jurisdiction for disputes. For example, if a company is registered in Delhi, it falls under the jurisdiction of Delhi courts. Third is object clause. The object clause is the most crucial section as it defines the purpose and scope of the company's activities. It is divided into main objects, that is the primary objects the company intends to achieve. Next is incidental or ancillary objects, activities necessary to support the main objects. Other objects, any additional activities the company may undertake that is not applicable to certain companies like private limited. For example, a company manufacturing electronic devices may include importing raw materials and leasing property as incidental objects. Next clause is liability clause. This clause states whether the liability of the company's members is limited by shares, guarantee, or is unlimited. Example, in a company limited by shares, members' liability is limited to the unpaid value of their shares. Next is capital clause. This clause specifies the company's authorized capital and the division into shares. For example, a company with an authorized capital of rupees 10 lakh may divide it into 1 lakh shares of rupees 10 each. Next is subscription clause. This clause lists the initial subscribers to the MOA who agree to take up shares and contribute capital. For example, if there are 5 subscribers, each must agree to take at least 1 share. Next is alteration of the MOA. The MOA can be altered, but as it is a public document defining the company's scope, alterations are subject to stringent legal controls. Changes ensure that stakeholders, creditors, and the public are adequately protected. Detailed procedure for alteration, that is, first is board meeting. The directors convene a meeting to discuss the proposed change and approve it. Special resolution. The resolution is placed before the shareholders in a general meeting. A special resolution, that is required approval of at least 75% of members, is needed. Next is approval from authorities. Changes to certain clauses like the object clause may require approval from regulatory bodies. For example, SEBI for listed companies. Next is registers filing. The altered MOA along with necessary documents like the special resolution and updated forms is filed with the register of companies. Notifications of alteration. Once approved by the registrar, the change is recorded and the company can legally operate under the altered MOA. Article, artic, Articles of Association, that is AOM. The Articles of Association complement the MOA by governing the internal workings and management of the company. While the MOA outlines the what of the company and the AOA focuses on the how. Now the expanded contents of the AOA are: first is governance rules, rules for conducting board and general meetings, quorum requirements and decision-making procedures. Next is directors' roles and responsibilities, provisions for the appointment, removal, and powers of directors. For example, the AOA may specify the procedure for electing the chairman of the board. Shareholder provisions. Rules regarding the issuance, transfer, and forfeiture of shares. Example, private companies may restrict share transfers to protect the company's private nature. Next is dividend policy. Procedures for declaring and distributing dividends to shareholders. Next is borrowing powers. Limits on the company's borrowing capacity and the conditions for issuing debt instruments. Winding up rules. Procedures for dissolving the company, including asset distribution. A relation between MOA and AOA. The MOA and AOA are independent yet distinct. The MOA sets the foundation, while the AOA builds the operational framework. In that we have two, that is subordination and complementary rule. Subordination, the AOA is subordinate to the MOA. Any clause in the AOA conflicting with the MOA is void. For example, if the MOA prohibits borrowing beyond rupees 10 crores, the AOA cannot allow it. Next is complementary role. The MOA provides the overarching purpose and the AOA details procedures to achieve it. Ultra-vires transactions. The term ultra-vires refers to acts beyond the company's powers as defined in its MOA. These transactions are void ab initio, invalid from the beginning, and cannot be ratified even by unanimous shareholder approval. For examples for this ultra-vires acts are manufacturing company engaging in speculative trading, which is not part of it. Sorry, am I audible? Okay, the examples for ultra-vires act are a manufacturing company engaging in speculative trading, which is not part of its object clause. A company borrowing funds exceeding the limit specified in its MOA. Exceptions of ultra-vires are statutory authorizations. Actions mandated by law cannot be considered ultra-vires. Implied powers. Acts necessary to fulfill the company's objectives. For example, hiring staff to run a factory. Next is doctrine of constructive notice. This doctrine places a duty on third parties to familiarize themselves with the company's MOA and AOA, which are publicly accessible. Implications. Third parties are presumed to know the company's powers and limitations. A contract contrary to the MOA or AOA is void. So these were the implications. Limitations of this are: the doctrine does not protect the company from internal irregularities, which are governed by the doctrine of Indo management. Now, what is Indo management? Doctrine of Indo management. This doctrine protects outsiders dealing with the company in good faith by assuming that internal procedures have been followed. Expanded principles. First is protection of good faith. Outsiders are not expected to verify whether internal approvals such as board resolutions have been obtained. Limitations are the doctrine does not apply if the outsider has knowledge of irregularities or if the act is ultra vires. For example, a director forging signatures on a document invalidates the transaction. Real world example is in Royal British Bank versus Turquoise, the court ruled that a leader could presume the company had followed its internal borrowing procedures, even though they were violated. In conclusion, the MOA and AOA, alongside doctrines like constructive notice and indoor management, create a structured legal framework for companies. These principles ensure accountability, protect stakeholders, and balance internal governance with external transparency. They collectively uphold the integrity of corporate operations while safeguarding public trust. So, this was the third unit. I hope you all understood. If you have any queries, you can email me. So, now we are going to start fourth unit, that is prospectus. These are the contents of the fourth unit. Prospectus. A prospectus is a formal document issued by a company to invite the public to subscribe to its securities, such as shares or debentures. It serves as a key source of information for potential investors, enabling them to make informed decisions. A prospectus is required when a company intends to raise capital from the public, particularly during an initial public offering. It discloses vital details about the company's financial position, operations, objectives, and risks. The definition of prospectus is according to Section 2, subsection 70 of the Companies Act 2013, a prospectus is defined as any document described or issued as a prospectus, including any notice, circular, advertisement, or other document inviting offers from the public for the subscription or purchase of securities of a company. Next is contents of a prospectus. The contents of a prospectus are governed by Section 26 of the Companies Act 2013 and must include the following key elements. So there are total 8 key elements. First is general information, name and registered office address of the company, date and nature of incorporation, name of stock exchanges where the securities will be listed. Second is capital structure. Authorized, issued, subscribed, and paid up capital. Details of classes of shares. For example, equity or preference shares. Objectives of the issue. Purpose for which funds are being raised. For example, expansion, debt repayment, working capital. Details of directors, promoters, and key personnel. Okay, the subject name is company law. Details of directors, promoters, and key personnel. Names, addresses, and qualifications of directors and promoters. Interest of directors and promoters in the company. Financial information. This is the fifth point. Past financial performance, audited statements and projections. Dividend policy and liabilities of the company. Factors. Possible risk associated with investing in the company, including market risk and operational risk. Seventh is terms of the issue. Price of securities, minimum subscription, and payment terms. Last is declaration. A statement by directors and promoters confirming the accuracy of the information provided. So these were the contents of the prospectus. There are in total 8 contents. Next is misstatements in a prospectus. A misstatement in a prospectus refers to any untrue, misleading statement or omission of material facts that could mislead potential investors. Misstatements can occur due to negligence, fraud, or intentional concealment. Types of misstatements. There are 2 types. First is untrue statements. That is incorrect information about the company's operations, financials, or management. And second is omission of material facts. Failure to disclose essential details that would influence an investor's decision. Next is consequences of misstatements. The consequences of misstatements in a prospectus are serious and can lead to civil and criminal liabilities for those responsible. So in consequences of misstatements, we have 2 liabilities, that is civil liability and criminal liability. Civil liability. Under Section 35 of the Companies Act 2013, any person who authorizes the issue of a prospectus containing untrue statements is liable to compensate investors for any loss or damage they suffer. Persons liable: directors of the company, promoters, persons who authorize the issue of the prospectus. Investors' rights are rescind the contract Investors can void their agreement to purchase securities based on misrepresentation. Claim for damages. Investors can sue for compensation for financial losses incurred due to reliance on false information. Now, second is criminal liability. Under Section 34 of the Companies Act 2013, criminal liability arises if the misstatement was made intentionally or fraudulently. The consequences of criminal liability are imprisonment up to 10 years for fraudulent misstatements, and a fine of up to rupees 3 crores or both. Directors, promoters, and officers involved may face criminal charges. The case example of criminal liabilities in Rex versus Kylescent, that is in 1932, the company issued a prospectus that exaggerated its financial stability, leading to significant investor losses. The court held the directors criminally liable for fraudulent misrepresentation. So this was the case example for criminal liability. Next, we have shelf prospectus. A shelf prospectus is a simplified prospectus that allows a company to issue securities multiple times within a specific period without having to file a new prospectus each time. Definition of the shelf prospectus is as per Section 31 of the Companies Act 2013. A shelf prospectus is issued by a company intending to offer securities to the public over a period of time, typically up to 1 year. Advantages of shelf prospectus are there are three. That is, first is cost effective, time saving, and transparency. So, cost effective is reduces the cost and effort of preparing multiple prospectuses. Time saving speeds up the process of issuing securities as the company does not need to seek approval repeatedly. Third is transparency. Investors receive detailed information upfront for all future issuances. Conditions for use are generally used by large public companies or financial institutions. Requires filing of an information memorandum containing details of changes since the last issue. The importance of prospectus is a prospectus serves as a bridge between the company and potential investors by providing transparency and essential details about the company's operations and financial health. It also establishes trust in the market and helps the company comply with legal and regulatory requirements. This was the importance of prospectus. Protective mechanisms for investors. Disclosure of risk allows investors to assess their potential exposure. Legal liabilities deter companies from misrepresentation and ensure accountability. In the conclusion of prospectus, the prospectus is a corner, cornerstone document in the process of raising capital from the public. It fosters transparency and trust by disclosing accurate and comprehensive information. However, misstatements can have severe consequences, resulting in financial, civil, and criminal penalties. Mechanisms like the shelf prospectus further simplify the process for repeated issuances, benefiting both companies and investors. Overall, a well regulated prospectus system ensures market integrity and safeguards investor interests. This was about prospectus, unit 4. So we'll just go through the overview of the third unit, that is Memorandum of Association. First, we have discussed about the what is MOA. Next, we have discussed detailed contents of the MOA. So there are in total 6 contents. That is name clause, registered office clause, object clause, liability clause, capital clause, subscription clause. Next, we have discussed about the alteration of the MOA. Procedure for alteration is 5. There are total 5. That is board meeting, special resolution, approval from authorities, registrars filing, notification of alteration. Next, we had articles of association, that is AOA, and the contents of AOA are there are 6. First is governance rules, directors' roles and responsibilities, shareholder provisions, dividend policy, borrowing powers, winding up rules. Next was the relation between MOA and AOA, that is subordination and complementary role. Then we had discussed about the ultra vires transactions. We had exceptions of ultra vires. Next was the doctrine of constructive notice. Implications were 2. In that is the third parties are presumed to know the company's powers and limitations, and contract contrary to the MOA or AOA is void. So these 2 were the implications, and limitations is the doctrine does not protect the company from internal irregularities which are governed by the doctrine of Indo management. Last was in third unit, doctrine of Indo management. So we had expanded principles in that. The first one was protection of good faith, and next was the limitations. And we also had the real world example. This was the third unit. Any queries from third unit? Okay. So, fourth unit, we discussed about prospectus, meaning, then definition. Next, we had contents of prospectus, total 8 contents of prospectus, that is general information, capital structure, objectives of the issue, details of directors, promoters, and key personnel, financial information, risk factors, terms of the issue, last is declaration. Then we discussed about the misstatements in a prospectus. There are two types of misstatements in a prospectus. The first one is untrue statements, and second is omission of material facts. Next is we discussed about the consequences of misstatements. There are two consequences. That is, first is civil liability, and next is criminal liability. Then we had the case example of criminal liability. Next, we have discussed shelf prospectus, definition and advantages of shelf prospectus. There are three advantages of shelf prospectus. First is cost effective, time saving, and transparency. Then we had conditions for use. Next is importance of a prospectus. Then protective mechanism for investors. Any queries from Unit 4? Okay, let's just go through Unit 1 and 2. Just an overview of the Unit 1 and 2. Unit 1, we discussed about, Unit 1 is about company. We have discussed about the meaning of the company, definition of company, characteristics of a company. There are total 9 characteristics. That is separate legal entity, limited liability, perpetual succession, common seal, transferability of shares, capacity to sue and be sued, separation of ownership and management, artificial legal person, raising capital, company and partnership. Next, we discussed about kinds of companies. There are 5 companies. They can be classified based on various criteria. There are 5 types. That is, first, based on incorporation. Next is based on liability. Third is based on membership. Fourth is based on control. Fifth is based on purpose. Then next was corporate veil. Lifting of corporate veil. Circumstances for lifting the veil. There are five circumstances. That is, first is fraud or improper conduct. Next is tax evasion. Next, third, agency relationship. Fourth is public interest. Fifth, improper conduct in group companies. Then we had exceptions. Exceptions when the corporate veil is lifted. So there were five. First is statutory provisions. Next is fraudulent and improper conduct. Group enterprises. Enemy character. Avoidance of welfare laws. So this was the overview of the first unit, that is company. Conclusion of the first unit is the concept of the company plays a crucial role in modern business, offering benefits such as limited liability, perpetual succession, and ease of resource mobilization. However, the misuse of corporate privileges necessitates mechanisms like lifting the corporate veil to ensure accountability, a clear understanding of the meaning, characteristics, and types of companies, along with the doctrine of the corporate veil, equips individuals to navigate the complexities of corporate law effectively. As business practices evolve, these principles remain essential for maintaining a balance between innovation, enterprises, and legal responsibility. So this was about the unit 1. Next, we'll have the overview of unit 2, that is incorporation. Procedure of incorporation. There are key stages in the incorporation process. There are 8 in total. First is choosing the type of company. Second is selecting a name. Fourth is drafting of documents. Third is drafting of documents. Fourth is application for digital signature certificates. That is DSC. Fifth is filing of incorporation documents. Sixth is payment of fees and stamp duty. Seventh, verification by registrar. Eighth, issuance of certificate of incorporation. Next, we had certificate of incorporation. Key features of the certificate of incorporation were, there are 3. First is legal identity. Next, details mentioned. Next is authority to operate. Then we discussed about the conclusiveness of certificate of incorporation. Legal implications are irrefutability, protection for stakeholders, binding effect. Next is promoters. The roles of promoters, there are in total 5 roles. First is idea generation, organizing resources, drafting key documents, ensuring compliance. Fifth is identifying directors. Next is responsibilities of promoters, fiduciary duty, disclosure of profits, liability for contracts. Next is pre-incorporation contracts. In that we have legal nature of pre-incorporation contracts. That is, there are 2, not binding on the company and personal liability of promoters. Next is ratification and adoption. Ratification is nothing the company may explicitly and implicitly ratify pre-incorporation contracts after incorporation. Next is novation. A new agreement is created between the company and the other party to substitute the promoter's liability. So the last was risk associated with pre-incorporation contracts. There are two risks. That is, first is promoters' financial exposure. Promoters may be held liable if the company fails to adopt the contract. Next is third-party concerns. Other parties may hesitate to enter agreements without assurance of company ratification. Hmm. The conclusion for Unit 2, that is incorporation, is the incorporation of a company is a meticulous process involving several legal and procedural steps. Promoters play a vital role in this phase, ensuring compliance and laying the groundwork for the company's operations. The certificate of incorporation is the ultimate proof of the company's legal existence, and its conclusiveness protects both the company and its stakeholders. Pre-incorporation contracts, though essential for operational readiness, require careful handling to mitigate risks. Together, these implements form the foundation for the smooth functioning of a corporate entity. So, this was the second unit. So, any queries from the second unit? Okay, I'm going to share a video. Please wait for some time. I'm going to share a video. Please to watch it. Any queries you can ask me.